Justice of the Appellate Division 4 Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall hear.
Please be seated. First case scheduled for argument today is case 834, People versus Belton.
Good morning, Your Honors.
Let's wait for your counsel to get settled.
Sure.
Thank you. Please proceed, counsel.
Good morning. Jessica Burgasser from the Niagara County Conflicts Office on behalf of Darrell Belton Jr. Mr. Belton comes before this court this morning asking the court to vacate his convictions due to ineffective assistance of counsel and jury prejudice. In the alternative, he's asking for his sentence to be modified, to be deemed illegal, and either vacated or modified. He was charged and convicted with possession of a weapon and with murder.
And he got consecutive sentences.
Correct.
And I believe that the theory is that he possessed the gun unlawfully, but hadn't decided he was going to use it for the murder, so that's what makes him legal.
Your Honor, I believe that that is the opposition to our position.
Right, so how can you refute that?
Well, we believe that the facts as presented by the prosecution at the trial indicated that Mr. Belton, I'm sorry, I completely lost my thought. We believe that the facts that were presented by the prosecution indicated that Mr. Belton murdered Mr. Riley because he wasn't going to complete the transaction. And the facts also indicated that Mr. Belton was aware that the transaction wasn't going to be completed prior to him going to Mr. Riley's home. There is no evidence as to when Mr. Belton possessed the weapon.
But we know he possessed the weapon before he entered the home, right?
Correct.
Okay, it wasn't there a conversation between the two concerning the transaction? In other words, some discussion about whether the transaction was going to be complete or not?
Your Honor, the facts indicate that that discussion took place via text with the eyewitness prior to Mr. Belton coming to the home.
And so there was no conversation in the home about the transaction. Is that what you're telling us?
That's my understanding of the testimony, Your Honor.
All right.
So we would present to this court that those were separate, that they were one action, that Mr. Belton obtained the gun and came to the home with the desire to commit the murder, and therefore the sentences should be concurrent.
We'll take a look at that, counsel. Thank you.
Thank you for your time.
Good morning, Your Honors. May it please the court, Laura Jordan on behalf of the Niagara County District Attorney's Office. Our position is obviously that the consecutive sentencing was proper in this case. My recollection of the facts was that there was a conversation in the home between the victim and the defendant for a period of time before the murder actually took place. We know that he walked into the home with the gun, that he pulled the gun from his own sweatshirt pocket. So,
And the idea here is that if there's a conversation, I mean, your position is if there's a conversation in the home, then the decision to use the gun had not been made at that point.
Exactly.
So the possession had taken place prior to any decision to use the gun.
yes, exactly.
All right.
If there are no further questions, I will rest on my brief.
I don't think so. Thank you, counsel.
Thank you.
Your Honor, if I may.
No, you may not.
Okay, thank you.
No rebuttal here, counsel. Case 835, People versus Brown.
Good
Proceed,
morning.
counsel.
Thank you. Good morning. May it please the court. The issue in this case is at what point an inventory search actually starts.
Yeah, and so your office had one yesterday. It was a similar issue. So I guess when I read the court's decision, they made a finding that the officer had not started the inventory and that he did observe, in plain view, and which follows as the automobile exception. So perhaps you can tell us why that's incorrect and why your position as I understand it, is that the inventory search had already begun and it wasn't done properly.
Right, so our position is that as soon as Detective Breen asked Mr. Brown to get out of the car, he was taking an affirmative step to start an inventory search. That he would not have seen those drugs in plain view if he hadn't asked Mr. Brown to get out of the car. And he testified the sole reason he did that was because he intended to tow the car and to do an inventory search. So the lower court's conclusion that it was just prior to the search commencing, the lower court doesn't explain what would have needed to happen for the search to officially commence. And that wasn't in the evidence because the people didn't present the Syracuse Police Department inventory search policy, for instance.
You agree that the officer had a right to ask the defendant to exit the vehicle?
Yes. The officer did pursuant to an inventory search, and the officer could have as a precautionary measure as well. We acknowledge that. But I think what's important is that that's not actually what happened here because the people.
When did it start is really the issue.
Right, right. And, you know, we acknowledge that the drugs were found immediately upon Mr. Brown getting out of the car. But I think it's not uncommon in many cases for contraband to be found immediately when a search begins. So the fact that it was found very quickly doesn't really matter. The fact of the matter is.
But did the search, I guess this is where I have a problem. What happens is he opens the door to get out and the officer sees it right there. So the search hadn't really begun yet. Nothing had happened. He hadn't even gotten into the car yet.
That's true. Our position is that the officer doesn't need to go into the car to start an inventory search. Inventory is just writing down the contents of what's in a car. So
How would you know what the contents are unless you actually got into the car, you looked at the glove box, you looked under the seat, you looked in the trunk? It takes more than just a visual examination, doesn't it?
certainly to complete an inventory search,
All right.
you would have to get into the car. But I think it can start before you get in. And when the defendant, when Mr. Brown is only getting out of the car for the purposes of an inventory search needs to happen, that's step number one in the inventory search. And even to the extent that, just to be clear, we're not asking for a bright line rule that every single time a defendant gets out of a car, that's an inventory search. But in this situation where the people didn't say what step one is, all the court can do is look at what's here, and what's here is, this is when it started.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the court, Jessica Carbone for the people. As Justice Carney noted, I actually briefed and argued the case yesterday that was similar facts, and as was the fact there, the people did not need to produce evidence of an inventory search here because there was no inventory search, as Justice Smith just noted. So, you know, I think our brief speaks for itself, so unless there are any other questions, I would rely on our papers.
Very good. Thank you,
Thank you.
counsel. Case 837, People versus King.
Good morning, may it please the court. Bridget Fields on behalf of Mr. King. Well, this case boils down to whether a parked car in a legally parked car at 5 p.m. with 3 people sitting in it gives an officer objective, credible reason to approach.
The standard is low. Isn't
It is
We're at a
good.
level 1 approach here. You acknowledge that.
Admittedly, it's low, but I don't believe
But
under
your
the
position
circumstances.
is just a parked car in a so-called high crime area is not enough. You need more.
Exactly.
Counsel, would it change if the facts change slightly? In other words, same circumstance and it's sub-zero temperatures or very, very cold temperatures and the car's not on and there's 3 people in the car and parked. Would the officer then have a reason to approach?
If the facts change, the answer would change.
Yeah, but I mean, but the idea
I-
here is, I guess what I'm getting at is, the idea here is that there wasn't a concern about the occupants in the car. There was no weather concern. This is September, right? It's not hot and the windows are up and the car's not running, there's no reason, your argument is there's no reason to approach this vehicle in the first instance.
Correct. This is distinguishable from so many cases that are out there. It is not, there was no allegation of a crime in the area. It
And
wasn't.
they were legally parked.
Pardon?
They were legally
They were
parked.
legally parked in a parking lot, and Officer Moran, I believe, testified that he had just arrived at the Skyline apartment. He drove through the parking lot, but there was no allegation that he had been
That's a hot
sitting
potato
there.
right now, isn't it?
Yes,
Are you familiar with Syracuse?
yes.
Yeah.
Yes.
But
And
that doesn't matter, right?
No, it
matter. There's a lot of
doesn't.
crime there, and this, I guess,
this just simply
happened
was,
before all the bad stuff they've been putting on the news every day, right?
it just simply isn't enough. He
Now, if
hadn't.
somebody was moving, if there was some movement that it appeared that they were smoking pot or something like that, that would change it.
They did not,
Yeah.
there was absolutely none of those facts in this case. There wasn't a driver slumped over at the wheel. There wasn't, the
Your
car
client's
had.
already done his, he's done with the,
My client is currently at liberty, has served his time.
and
but
has nothing else, no post-release supervision or anything.
My recollection is
Yeah.
no, because I believe
Yeah.
this was an indeterminate sentence, if I'm
Yeah.
remembering
Right.
correctly. But he is absolutely at liberty, but of course, the reversing the conviction matters, certainly. And just think that this is, I cited quite a number of cases that I believe are distinguishable. There just aren't enough facts to approach a legally parked car at 5 PM on a day where weather isn't a concern, and there's been no allegations
There's
of
nothing else
crime.
other than they're just sitting in a parked car in a parking lot.
Correct. There wasn't
Nothing.
even an allegation that they saw, like a lit cigarette or a lit, something lit or smoke.
Not people approaching the vehicle, they hadn't been parked there for hours, there's just nothing.
No, the only testimony was that the car was parked
And not running.
and not running, and Officer Moran approached the parking lot. There was no testimony that he was there for any length of time other than to drive the length of the parking
I
lot.
think
So
we
it
have
was,
that argument, Counsel.
thank
Thank
you.
you.
Good morning again, Your Honors. Jessica Carbone for the people.
So is it enough that it's a high crime area?
No, standing on its own, Your Honor, that wouldn't be enough, but I think we did have more here.
Give us that, what is the objective, credible reason to approach this car?
So Officer Moran testified at the suppression hearing that he pulled into a very occupied parking lot. He said that he drove through the lot of what he knows to be a high-crime area and observed about 20 cars. All of them were parked and empty. When he got to the vehicle that the defendant was in, it was the only vehicle in the lot that was occupied, and he noticed that the occupants were neither exiting the car to go inside or, putting it in drive and driving away. They were just sitting there. And at that point, Your Honor, under the law of cases like Witt and Ocasio, I think he was authorized to approach the parked vehicle just to ask basic questions, name and things like that. And that's exactly, he testified that that was his intent. However, as soon as the occupant rolled the window down, he identified the odor of marijuana.
Yeah, it's really about the approach.
Yes, but I would submit, Your Honors,
So if
that,
I sit in the parking lot for 15 minutes by myself and just stare off into space, the police officer can come up to me and that's enough?
well, I guess the first part I want to say, I don't know how long he witnessed the defendant's vehicle, so I don't know if it was a period of 15 minutes or anything like that.
So
But-
it was a couple minutes, because that's as much as Moran observed it, right?
Correct.
So that's enough according to your argument?
I don't think that you standing in the sitting in the parking lot, just staring off into space necessarily would be enough. I think what
I
Officer...
don't do that often, don't worry.
We worry about him.
Understandably so.
Officer Moran testified that what piqued his attention is that the folks inside the vehicle weren't leaving. This is
But what if
a...
you were waiting, you could be sitting there waiting for someone to come out of an apartment to be picking somebody up. I just don't see how that really plays into this.
I think that's exactly what authorized him only to ask the basic questions. He wasn't going in to initially remove them from the vehicle and search the vehicle.
Okay, I think we have that argument,
Okay,
Counsel.
thank you, Your Honor.
Thank you. Case 838, People versus Cannon.
Good morning, Your Honors. May it please the Court, Robert Kemp on behalf of the appellant, Lawrence Cannon. Today, I'd like to focus on points 1 and 2 of the brief. And although the police are not obligated to refrain from questioning a young adult in absence of their
Your argument is that they isolated him essentially here, but was there something in addition to the isolation, some deception or trickery? Because that's kind of what we're looking for here, right? Is isolation enough?
I would say so. I would say that it was official concealment, both in my brief and acknowledged in the People's brief, is that Buffalo Police Officer Molly Sanford left the office, left that interview room a few times to discuss this situation with another detective and became aware that a parent was there, whether it was the mother or father, they were not sure. So she became aware that a parent was there. She did not inform the appellant that a parent was there. When asked on cross-examination, she said...
We also know from the record, don't we, that the parent showed up
Correct.
After the interview had started?
That's true.
Okay, so you're saying that even in the middle of an interview, if a parent shows up, the officer's required, if they find out the parent's there, to stop the interview, go out and talk to them? What are the requirements of the officer at that point?
I don't know if they're required to tell, but I would say that I would truly believe this would be grounds for official concealment of not telling Lawrence Cannon that a parent showed up. I mean, this is a 16-year-old youth with barely any criminal record whatsoever. He had some minor marijuana offense a few years prior to this. No criminal record whatsoever besides that. He's 16 years old. His parent definitely one of the parents definitely comes to the police station. They obviously isolate him. I would say it's official isolation of this young 16-year-old from a parent who shows up. And obviously this parent's intention is to see their son and possibly invoke the right to counsel, because a parent can invoke the right to counsel on behalf of a young adult. And that's from People versus Mitchell, cited in my brief.
Did the father testify at the hearing?
The father?
Or whoever the parent was that...
No, neither parent, no, we weren't sure whether it was the mother or the father.
Oh, yeah.
There was some ambiguity there.
Whichever parent.
But neither parent testified at the hearing regarding this. But I would consider this official concealment. They knew it. They were isolating him from a parent. They did not inform him that the parent showed up. I would say this definitely would be the definition of official concealment. And going to point 2, and obviously acknowledged in my brief and in the People's brief, the lower court failed to make a determination whether he was eligible for youthful offender adjudication. So whether this court...
You're asking us to send it back to remit it?
Correct.
Okay, very good.
Thank you.
Counsel. The last point first, you acknowledge that determination wasn't made, and we should probably remit this?
Good morning, Your Honor. Danielle Phillips. Yes, I do. May it please the court. Yes, Judge. The lower court did not make a determination as to the defendant's YO status. It does need to be sent back. The people's position on that, though, is that the defendant should not receive that status, and we'll make that argument at the lower court if this court so chooses to
With
send it back.
respect to point 1, the isolation, is the isolation enough?
No. Your Honor, this is not a case of official concealment. Essentially, Your Honor, the record for the suppression hearing is very clear. Detective Sanford was questioning the defendant. At some point, it's unclear as to when she found out that one of the defendant's parents were present.
We know that the interview had started, though.
Yes, it had already commenced. Yes, she did leave the defendant in the room to obtain information from another detective to inform her further questioning of this defendant. However, Your Honor, that does not amount to official concealment. There's no deception here. There's no trickery. The record is completely devoid that the officers or any Buffalo police officer tried to keep the defendant away from his parents. And there's no obligation to tell the defendant that his parent is present. And there was...
Counsel,
yes,
didn't the court hold the proof open to give the defense an opportunity to bring in the parent?
That is correct, Your Honor.
And did that ever happen?
No, Your Honor. I believe that they rested without having that testimony. And unless there are any other questions, I will rest upon the remainder of my brief.
Counsel, thank you.
Thank you.
Case 839, People versus Myers. While council are approaching, I'm going to use this as an opportunity. I probably should have started with this, just to remind all the people that are coming to argue, all council that are arguing, and while you're sitting in the back, that it's important that you keep your mask fully up and over your nose and mouth all throughout your stay here with us in the courtroom. Thank you. Council, proceed.
May it please the court, Tyler Bugden on behalf of Michael Myers. Prosecution has a burden of demonstrating that it strictly complied with requirements of CPL 700.70. Under the statutory text, the case law, and the facts of this case, it's clear that the Attorney General wiretap intercepted Mr. Myers' conversation.
Well, there was consent to have that happen. I mean, it was being recorded, and one of the parties knew that because they were in the Justice Center, and the recording had gone on that says this will be recorded, so there was consent.
The Justice Center recording is evidence derived from an intercepted communication. And my analysis begins with the statutory text and the definition of intercepted communication. Under CPL 700.05 subsection 3, the conversation intercepted by the Attorney General's wiretap was an intercepted communication because the Attorney General did not have consent to intercept that communication. It's undisputed in this case. Furthermore, courts consistently treat conversations overheard via wiretap as intercepted communication. And here I'm referencing...
Not when one of the parties has consented to have it recorded and they know that anyone can be listening to it. That's a difference.
Well, again, my analysis begins with the statutory text, the definition of intercepted communication, and the wiretap here fits squarely within the definition of intercepted communication. And the Justice Center recording, as admitted by the prosecution in open court, is evidence derived from the intercepted communication. The prosecution admitted in an open court and in a letter to the court that it was alerted.
Yeah, I think we have that argument.
I'd just like to further explain to your honors or argue that absent explicit command from the legislature, courts should not read judge-made Fourth Amendment exceptions into the statute. And here, what respondent is arguing is essentially an independent source doctrine exception or a transfer of consent doctrine exception into the text of this statute, yet respondent fails to cite any text of the statute that suggests that the definition of intercepted communication has an exception for independent source doctrine or transfer of consent. That consent to record the Justice Center recording was never transferred to the Attorney General investigator who was listening to the wiretap. Moreover, the independent source doctrine is inapplicable here because...
Does it matter, counsel, that the actual recording came from the Justice Center's recording and didn't come from, as I understand it, the actual intercept?
It matters, yes, Your Honor, because it's evidence derived from the intercept. As explained by the prosecution, they were alerted to the Justice Center recording because of the intercept. And as explained at trial...
But the recording wasn't generated because of the wiretap. You're saying that it flowed from the wiretap because that's how they learned of it. In other words, but for the wiretap, they would never have learned of this recording. This recording would never have been revealed, and that, of course, would benefit your client.
Correct.
That you don't even know, because they could be listening to it later and say, oh, well, listen to this, and it could have been used anyway.
Well, Your Honor, what we do know is that the prosecution said that they were alerted to the Justice Center recording because of the wiretap.
Okay,
and so inevitable discovery doctrine was never raised below. An inevitable discovery doctrine, there's no evidence on record to suggest that this Justice Center recording would have inevitably been discovered. At trial, Deputy Reschke, who manages the Justice Center recording system, testified that the Justice Center recordings, in order to search those, they're identified by the inmate or the individual who places the call. Michael Myers did not place the call from the Justice Center. It was another individual who placed the call to Mr. Harris. Then Mr. Harris made a three-way call to Mr. Artell Clark. Artell Clark's phone was under a wiretap by the Attorney General. Artell Clark then put Mr. Myers on the phone. The Attorney General investigator who was listening to Artell Clark's phone only was able to identify Mr. Myers because he knew Mr. Myers' voice and he was participating in this ongoing hit-and-run
I
investigation.
think we understand that.
So under the text of the statute, which defines contents of intercepted communication as identities, the prosecution essentially was able to discover this Justice Center recording because of the identities shared from the wiretap investigation with the prosecution.
Yeah, I think we understand.
So accordingly,
your
under
argument.
CPL 700.70, it is evidence derived therefrom.
Thank
And
you,
it must be
counsel.
suppressed.
Good morning, Your Honors. Ken Tyler for the people. We don't even get to the derived from question because it's not an intercepted communication. I might see it differently if we had to rely on the wiretap recording. We didn't hear because it was a jail call. I ask you to affirm.
Thank you, counsel.
Thanks.
Good point.
Case 840, Clark versus Clark. Well, Counsel Pierce, you're alone.
Well, good morning, Your Honors. May it please the Court, Catherine Friedman representing petitioner respondent Chelsea Clark. Unless you have any questions, I will rest on my brief. I believe that the record amply demonstrates that there was a sound and substantial basis in the record for family court's decision as well as for the court's best interest analysis. And unless you have any questions.
No questions, counsel. Thank you.
Okay, thank you.
Case 841, Fowler versus Rothman. Proceed, counsel.
Good morning. If it pleases the court, Rebecca Contz for the appellant. I'd like to start off with our point one in the brief about there was insufficient change in circumstances to warrant.
Didn't your client move for a change too?
She had filed a violation petition, so she was sort of arguing that there wasn't a change and the 50.
She was seeking custody.
She was seeking sole
Which
custody.
could only be based on a change in circumstances.
That's correct.
Okay, so can't we go beyond change in circumstances and look at best interest?
We-
Because it looks like both parties seem to agree, from my read of the record, that there was a change in circumstances, and it wouldn't be a big stretch to get there either, right? Because they clearly weren't having a very good relationship.
The parents' relationship had deteriorated, but the mother was still fostering that interaction with the father
By making those complaints? against the
until
father?
the allegations
Okay.
came in.
Why don't
And
you take us to best interest, if you would, please, for my sake, subject to other questions.
if she hadn't made those disclosures and gone forward with contacting the authorities, then she would have been in more trouble if it turned out that she hadn't reported these. She has a long history of issues with the father, and she's trying to prevent the same from happening to the kids. She's proven that she's, nurturing, caring mom. She's taking them to appointments. She's making sure that the father's notified when they go to appointments, whereas when he had custody, was not giving her the same benefit. He unilaterally changed schools without telling her.
If the record reveals that she's getting the son to make false statements about the father, is that a sign of a caring, nurturing mother?
I don't think there's enough evidence in the record to say that she was actually coaching him. When the police officers came and spoke to the child, there was no indication from the child that, mom told me to say these things. It wasn't until later when the father had full custody that it started being like, oh, there was this coaching, when the father had full control. And the judge even admonished the father when he started wearing a recording device to drop-offs that the father's actions were contributing to the kids not wanting to visit the mom. So there was stuff behind the scenes later on when the father had control. He unilaterally changed schools on the kids. He didn't put the mom on forms. He informed the school that he had full custody before he really did. He was telling them that.
It is a fact that there were, I think, at least 5 unfounded allegations of child abuse made by the mother.
There were several.
But she refused access on that basis too, correct?
Anytime she refused access, it was after discussing it with people in authority. So she was trying to the best of her ability to follow the directions that she was provided.
Anything further, counsel?
One last thing, I just wanted to touch quickly on the respondent's brief where they claim that the subsequent decision would moot this one.
That order says it continues custody.
Yeah,
And that's
so
sort of a big difference right there.
Right, yep, the custody, it wasn't changed, so, that's the big issue. It modified the visitation, but it didn't address that custody issue. If
Thank you,
there's no further
Counsel.
questions, thank you.
Good morning, may it please the court. Linda Campbell for Mr. Rothman. First of all, I probably needn't remind the court that this particular portion of the litigation started in February of 16 when the mother filed her first petition, which was itself dismissed for failure to prosecute, subsequent petitions following her own, starting that process again. During the course of those proceedings, in approximately August of 2016, so 6 months later, the father first gains custody, full custody of the children as a result of a petition filed by the Onondaga County Department of Social Services alleging the mother's neglect. And from that point, so from August of 2016 up through and continuing today, the father has had sole legal custody of the children with varying degrees of visitation to the mother over the course of this litigation. I'd also advise the court as an officer of the court that as of this morning, I spoke to Onondaga County Family Court. There are 2 petitions, both V-docket petitions pending in family court with these 2 parties. But possibly of significance is the fact that in October of 2020, just a little over a year ago, after a full trial was conducted in family court, the father was again awarded or continued, if the court would prefer to use that word, custody of these children with visitation to the mother. So this has been protracted litigation. In response to Judge Curran's comments and question, change in circumstances, clearly there's been a change in circumstances here. We have 8, 9 complaints filed by the mother with various and sundry agencies alleging physical abuse, emotional abuse, and then the capper of all cappers, sexual abuse
Well,
involved.
do we even need to get there when both sides are taking the position that there's a change in circumstances by seeking a change in the custody?
I don't think so, Your Honor, particularly since even in the briefs filed on behalf of the appellant, she's seeking custody, which in order to get there, you have to have a change in
You
circumstances.
can't get there without the change.
Can't get there from here.
Yeah, and we
Exactly.
follow the doctrine of, it's just a waiver, not that we compare each one of the allegations. We just say if there's 2 petitions, a petition, a cross petition, we move on to best.
I like that, Your Honor. I like that a lot. And so in terms of the best interest, we've got 2 parents that, at least on paper, should look similar. However, you've got a mother who is
The court
filing.
gave it a careful look.
Correct.
And heard the proof that Justice Joseph summarized a few minutes ago about the 5 at least unsubstantiated allegations of abuse. I made the comment about withholding custody on that basis, and the court gave it a good look.
Correct. I have one more point, and this is in response to Justice Whalen's inquiry and the response too. The mother admitted during her testimony that she encouraged the children to use what she characterized as safe stories to protect their interests. Those were lies. So she's encouraging the children to lie. I think that in and of itself. No further questions? I'll rely on the brief.
Thank you, counsel.
Thank you.
Case 844, Formusa versus Formusa.
Good morning, Your Honor.
Mr. Sarando, welcome.
Thank you. Taking the last admonition from Your Honor, I will attempt to keep my voice up through the mask. This is an appeal from an order confirming a willful support violation of spousal support. The crux of the case involves bankruptcy law. And I know this case has been here before, but I submit that the record in this case is, it was adequately and properly presented in this case here. So I think the court has to reach the issue of whether or not the failure to disclose in a bankruptcy petition the $4,400 a month support obligation voids her standing to bring a violation of that order. When you look at the petition that was filed, it was the $189,000 judgment was specifically listed, but the underlying obligation was not. And I think it's very clear that she didn't have standing. And as this court, a wise justice of this court with sitting in the middle last week told me, can't we always get to subject matter jurisdiction, Mr. Sarando? And once again, Judge Whalen, the answer is yes. So I think that the issue is ripe.
Do we have to look at really the specific language in the petition and what was mentioned? In other words, some indication that maintenance was owed, if not the full amount listed? Does that make a difference? Or are
No.
you saying the full amount of the claim has to be listed, and short of that, she loses her right to proceed?
I'm saying the obligation has to be.
Yeah, as I understand your argument, are you arguing that, in other words, it's not an underreporting the value of an asset, it's the non-reporting of a stream of income?
Of his, yes, of his stream of income, yes.
But I guess to Justice, to the presiding justice question, there is some case law that talks about underreporting, level of specificity. Does it, is it sufficient to enable the trustee to determine whether to investigate further? So I guess the question would be the fact that the money that was due was even if underreported, was listed, wouldn't that in turn also tip off the trustee that there probably was an ongoing obligation to pay this support?
Only if the trustee had come in and said there's an underlying obligation. I think on this record, it's sufficient to show a lack of jurisdiction. And I think this falls within this court's decision in Green, where you said you didn't list it, but you knew about it. I think this is the same analogy.
We'll take a look at that, Mr. Sarando.
Thank you.
Thank you, counsel. Case 847, Salisbury versus Dufresne. Counsel, proceed.
Thank you, Your Honor. May it please the court, David McKnight, appearing for the plaintiff appellant, Vicky Salisbury.
You rely on a series of our cases, starting with Logan, correct?
Yes, Your Honor.
And neither the court nor your opponent here cited to those cases?
That is correct.
Is it your position that those cases are essentially on point here with respect to the inextricably intertwined issue?
They are, Your Honor. By the way, the one case that Supreme Court cited also, although it was described in the opinion as intertwined, that case is identical to the Logan decision, because if you read the second page of the opinion, it uses the term inextricably intertwined, which is the same as the Logan, the contracts are inseparable. In this case, if these contracts are not inextricably intertwined, the plaintiff should have had a judgment for the $180,000.
And then what?
And then the defendant had a right to continue on the severed action to enforce the employment contract and the non-competition agreement. Now, if the defendant had done that, the defendant had a limitation on damages, Your Honor, of $1,000 per tax season.
Tell me something. Is there, in fact, a non-competition agreement anywhere in the record?
The employment
There's an
agreement?
employment contract, but is there a non-competition that was part of the, apparently supposed to be part of the consideration here? What was going to be conveyed? The business plus, the non-competition agreement. Was that ever entered into?
No, Your Honor. There was no separate independent non-competition agreement executed. There was a non-competition agreement in the employment agreement.
So what do we do with this issue that the non-competition agreement that would have been related to the sale of the business, as opposed to the non-competition agreement that's in the separate, according to your argument, employment agreement? What do we do with that issue? Because that was probably worth something, wasn't it?
Well, Your Honor, the fact of the matter is, there was, as I read the record, there was a reason for the absence of a specific non-competition agreement. If you look at the defendant's affidavit, you'll see that first at paragraph 10, the plaintiff was eager to retire. This is the defendant's testimony. Secondly, the defendant also testified that she viewed the plaintiff as a surrogate mother. There was a very close relationship. Thirdly, the defendant in paragraph 8 of her affidavit said that the plaintiff had pressing family obligations. And in the document she said that there was the plaintiff was engaged in family activities throughout the period after the closing of the sale on October 31st. So there was
a further interruption here, is that the defendant never expressly waived the requirement of the non-competition agreement that was supposedly going to be attached to the sales contract. That was not expressly waived, right?
It was not expressly waived, and it was not expressly reserved.
Well, we know this, there was no allocation of the purchase price. That schedule was missing too, which, ordinarily that's what you do, and you would attribute certain monies to certain tangible and intangible assets mostly for purposes of, tax issues for the buyer and seller.
That is correct.
But if you had that and there was no allocation as to this non-compete, maybe you'd say, well, it's more likely that it was waived or wasn't part of the purchase price, but you don't have that either, I guess.
Well, that is true, and that brings me to a fundamental disagreement between the parties as to the nature of this transaction. The plaintiff's view is that the transaction was a sale of a business, and there's reason for that. The letter of intent says sale price for the business, $200,000. Well, that's at record 39 of the record that the defendant signs off. That is the sale price.
Your position, basically, as I read it in your brief, is this was an ongoing concern. It had gross revenues of roughly, $2.25, $250 per year. Before it was sold, the defendant was able to acquire a ready-made business, whatever it may be. and telephone number, got an assignment of the lease, so that's why you're saying it's a sale of business. Do I have basically the facts correct?
Absolutely. And those are values. By the way, there's a judicial admission that this was a sale of a business, because that's what the defendant's answer says. In particular, she says, in October 2016, Durfee purchased Salisbury's tax preparation business, paragraph 17 of her affidavit.
We know the record fairly well, sir, so in terms of, I guess your argument would be at a minimum, and I'm not saying that I agree or disagree, at a minimum, you get judgment on the note, the case proceeds on the covenant not to compete in the employment agreement, and to the extent that if this non-competition agreement, the sales agreement, was waived, has any value, whatever, that all awaits another day. That would be your sort of your fallback position?
That is part of it. The other part is that there's no evidence, admissible evidence, of record to support a claim of a violation of the non-competition agreement. There's hearsay, but that's not sufficient. There's surmise, and surmise is not sufficient to support it. The one element that is tangible, and it comes from my client's record, is she purchased a tax book. She explains it in her reply that it was a tax book.
That's sort of inconsistent with retirement, isn't it?
Not exactly. She'd been in the tax business a long time. I've been a lawyer for 50 years. I can't put down law books. It goes along. Is it absolutely positively consistent? No. Is it something that changes? By the way, I would be flabbergasted, and I think the court would be flabbergasted, if H&R Block was selling software that allowed it to conduct a business and file tax returns for a sum of under $110. That's simply not a reasonable view of how people do business.
Counsel, you should begin to wrap up.
Thank you very much, Your Honor.
Thank you.
May it please the court, David Roach on behalf of Nikki Durfee. The central legal question here is whether there's a contract that requires as consideration entry into another contract.
Well, you walked out of the closing without a non-competition agreement.
First of all, there's a further assurances clause in the sales contract that essentially says, as other further assurances clauses do, that you have to provide whatever is necessary to effectuate the transaction. So there were other schedules.
Was it ever demanded?
It was, because both parties knew that it was going to be contained, the covenant not to compete was going to be contained in the employment agreement, and the employment of Ms. Salisbury was inevitable. It was just simply delayed.
But the employment agreement could be terminable at the option of either party, couldn't it? Is that different than the covenant not to compete?
Well, no. The employment agreement, again, contains the covenant not to compete, and the covenant not to compete would mirror exactly the language that would have been contained if it was in a separate document.
Let me ask you this. If I were to walk into H&R Block and say, I've got an accounting degree and I'd like to, pick up a little employment, is that same employment agreement they would have me sign?
I think it is a boilerplate H&R Block document. Okay. So, and that would, again, point to the fact that the parties knew that that would be the contract and that it would contain that covenant not to compete language. To the point that, if this was not the covenant not to compete that the parties contemplate in the sales agreement, then we have a massive failure of consideration. We have presented parole evidence.
Consideration doesn't take much under the law. And certainly your client has been now running a business for approximately 5 years for which he's only made one payment. So there's consideration for the sales contract and there's consideration for the employment agreement, albeit maybe not much. But your complaint is, hey, I never got the non-competition agreement that you promised me I get. And a deal's a deal.
Correct.
So that's worth something. I get something for it, is what you're trying to say.
Correct. Yeah, I
But
mean-
they still get payment on the note under that circumstance, right?
Yes.
Okay.
I mean, the objective here of the lower court in here is to determine what the intent of the parties was. What's the first thing we do? We look to the plain language of the contract. What is the plain language of the contract in terms of consideration? Purchase assets, number one, and the covenant not to compete. Two things. That's it.
We know the record pretty well, Mr. Roach. The question is, though, for me, you heard what I initially asked your opponent there, is that neither the court nor you in your brief address Logan and the 3 other cases that we have that cite to Logan. And Logan, I don't know if it's consistent or inconsistent with the other departments. I'm not sure I care. But Logan seems to be directly on point with respect to this issue.
I think, Your Honor, if we also look at the other cases that defendant is cited to, the Marks v. LaRouche case, Frank v. Weiss, Servinsky versus Resitz, McCann versus Ballantine Marine. Those are cited throughout the defendant's,
Those are the
the
4
plaintiff's
cases I'm
papers.
talking about.
Correct. And also.
And you don't discuss them at all in your brief.
Well, Your Honor, here's the clear distinction, and this distinction is well laid out in the brief. The key factor as to whether 2 contracts are intertwined is whether one contract is consideration for the other. If you look at all those cases, Marks, Franks, Stravinsky, McCann, not one of those cases involves a written contract that requires as consideration another contract. They have related subject matter. The courts say it's related, but it is missing that key factor, which we have in A-plus Associates, Fitzpatrick, Regal Limousine, in this case.
So that's what you want us to look at?
Correct.
Okay.
Thank you, counsel.
Thank you.
Case 848, Revere versus Burke.
Good morning, Your Honors. May it please the court, Gabrielle.
Counsel, let's wait until everybody gets situated,
Sorry.
if you don't mind. That's fine.
Gabrielle Bull on behalf of Dr. Stella Castro, nurse practitioner Lindsay Petrie, and Asthma and Allergy Associates. There are 2 distinct errors that the lower court made here in denying defendant's motion for summary judgment, in that they found that the plaintiff's expert affirmation submitted in opposition was both qualified to render the opinions contained therein, as well as was based on...
What opinion is in controversy here? That expert said, among other things, that Dr. Castro did not comply with the standard of care because she did not in any way communicate with Dr. Burke after the referral was made. So that has nothing to do with medical procedures or the course of treatment. It just has something to do with communication between the referring physician and the expert.
Well, Your Honor, there are actually 2 distinct purported opinions or findings that the plaintiff's expert claimed that Dr. Castro reached. The expert claims that first, she concluded that allergies were not the cause of the patient's loss of taste and smell. Now, the record blatantly contradicts that. Both Dr. Castro's records from that presentation state that she was starting the patient on medication, specifically nasal steroids, to see if those symptoms could be alleviated. And second, the expert also claims that Dr. Castro conclusively determined that a CT scan was definitively needed to further evaluate. Those are the 2 opinions which the court found raised a question of fact sufficient to meet their burden. But the medical records, Dr. Castro's testimony, both blatantly contradict those findings. In fact, her notation specifically said CT scan versus rhinoscopy may be needed.
Do you agree with this, however, that a plaintiff's expert would be qualified to render an opinion regarding the obligations of the doctors to communicate with one another?
Absolutely not, Your Honor, when the communications are coming from a specialist. The threshold question in terms of a medical expert's affirmation has always been whether or not the requisite foundation has been laid to give those opinions. Now, this affirmation, if this were at trial instead, the expert would have been allowed to take the stand without establishing that they were familiar with the standard of care for an allergy specialist, give
No,
their
he's
opinions.
saying I'm familiar with the standard of care as an internist. When I refer patients to specialists, there's an obligation of communication there. Is he qualified to render that opinion?
The issue with rendering that opinion is, as I'm sure this term is a favorite, it depends. So here, the expert's ultimate conclusion that there should have been communication was with regard to those two specific purported findings. So it's essentially those two errors combined into one. Moreover, whether or not Dr. Castro actually reached those conclusions and findings in her capacity as an allergy specialist requires a familiarity with the standard of care for allergy and immunology medicine.
But it is undisputed that Dr. Castro never did get back to Dr. Burke.
Because
That's not disputed.
that's not disputed, Your Honor, because she never was able to obtain an answer to the very question that Dr. Burke sent the plaintiff to her for, which was, what, if any, of the patient's symptoms were caused by allergies?
But didn't Dr. Castro say somewhere in her reports that the plaintiff's problems could not be explained merely by allergies, that her problems were more complicated than that? Didn't she come to that conclusion?
In the specific language of that she noted
Words
in
to
the
that
record,
effect.
she said, my best guess is that even if the patient doesn't have allergies, or does have allergies, it may not explain her symptom complex.
Right, there's something else going on here.
Exactly. So her duty was to figure out, as our expert, who is an allergy specialist, says, her duty was to determine what, if any, of those symptoms were caused by allergies, to eliminate them from the symptom complex of those symptoms that weren't yet determined what the root cause of them
Isn't
was.
that what should have been reported? That even had I completed my allergy studies, there's something else going on here, because allergies could not explain her symptoms.
But that was the question that she was unable to answer because she was never able to complete her testing.
Okay.
And as Your Honors, in Chills v. Brendan, it was established by this court that, and we do not dispute that an expert can offer an opinion outside of his or her specialty, but the requisite threshold question is whether or not there is a foundation for that opinion. And the key here is that the lower court specifically did not find that that familiarity with the standard of care for an allergy specialist had been established. Instead, the court reverse engineered the analysis, used the expert's ultimate opinions to then evaluate his qualifications as to whether or not to render those opinions. And those opinions, as I mentioned, were based entirely on blatant misstatements of the record that are completely contradicted. Indeed, while the expert claims that Dr. Castro concluded that a CT scan was required urgently, she hadn't even concluded whether or not a CT scan or a rhinoscopy was needed. And unless Your Honors have any other questions in regards to our third point, I will rest on my brief.
Very good. Thank you, counsel.
Good morning, Your Honors. May it please the Court. Tom DiBernardis on behalf of the defendant appellant, Dr. Burke. As this Court well knows, you don't get to the question of standard of care unless there is a legal duty in the first instance.
Yeah, so really this is all about a GP or, referring somebody out to an expert and whether that discharges the duty.
Yes, Judge. Here you have an instance where
A little bit, this is a little bit different, and I'll tell you where, at least where my head's at, there's two things that are going on. One is, let's assume that it was an orthopedic issue, that's pretty clear, I'm a general practitioner, I don't know much about that, and I just send the person on. This is a little bit different, and I know that we do understand the discharge of a duty with the sending on to an expert or a specialist, and we also understand that if it was merely just sending out for tests, that would be different. And you're suggesting that this falls in the discharge by just sending on to the specialist. But let me ask you this, when she came back and after she was referred out in September of 14, there seems to be at least a little bit of a factual dispute on whether or not she told him, the doctor, Dr. Burke, that she continued to have a loss of taste and smell. And if that is a factual dispute, then wouldn't that, so to speak, reactivate the duty of Dr. Burke to inquire and say, hey, what's going on with this? And perhaps have to, resend her out to a specialist?
No, Your Honor, because there isn't a factual dispute here. And I would point the court to the reply brief, namely the Cruz decision, the Perez decision, and the dissent decision. In that case, the plaintiff attempted to do exactly what the plaintiff is attempting to do here. And that's make it seem as though there actually was a question as to whether there were reports of the relevant symptoms and whether or not.
We know that Dr. Burke, at least in his report, and I think it's September of 14, in his records, he says he didn't inquire, right?
That's not correct. He did inquire. In fact, in his deposition testimony, he testified that at every visit with a patient, he asked them specifically, do you have any ear, nose, or throat symptoms?
What did he say? What did he say in his deposition as opposed to his affidavit in the summary judgment context on this issue?
In his deposition, he was asked specifically whether or not.
He said he didn't recall.
He said he didn't recall, but he did also say that at every visit, while he might not there sitting at his deposition testimony several years later have a specific recollection.
Right, he didn't remember, but then in his affidavit, he said that she never complained about it. So there's a little difference there, isn't there?
Not necessarily. I would say there is not, Your Honor. He's saying that she didn't complain about it based on a subsequent review of his medical records, in that he, as he said in his deposition testimony, at every visit, he asks a patient, do you have any ear, nose, or throat symptoms? He documents in his chart, ear, nose, and throat within normal limits.
Let's turn to her then, okay? She says at the deposition that she doesn't remember, right? Is that correct?
You're referring to the plaintiff, Your Honor?
That's right, yeah. So she testified she didn't remember if she told Dr. Burke about the loss of taste and smell in 2014.
She does say that in her deposition.
That's accurate, right? Okay, and then she puts in an affidavit and says she finds it hard to believe that she would tell the allergist, the Dr. Castro, that she was continuing to have those types of problems with taste and smell, and that she wouldn't have told Dr. Burke.
That's correct. She does say that.
So does that create a question of fact?
No, because that's a classic case of a plaintiff serving a self-serving affidavit to create a feigned question of fact in contradiction to their prior testimony.
Well, her prior testimony wasn't that she didn't tell Dr. Burke, she just didn't remember.
She did say that, but I would submit, Your Honor, that the fact that she is authoritatively saying in her affidavit in opposition to the summary judgment motion that she finds it hard to believe, that's equivalent to feigning a question of fact here. Okay. Here you have a plaintiff who, I'm sorry.
You have to keep in mind, whose burden is this now? It's your motion.
Well, the lower court said that we met our prima facie burden. In the briefing subsequent to that, there hasn't been any dispute as to whether or not we met our prima facie burden. So the question here is whether or not there's a triable issue raised by the plaintiff.
Well, that's it. Is there a factual issue here? Did she raise a factual issue when she said, you know, as Justice Carney pointed out, I must have told him because I told Dr. Castro just a few weeks later. That's why I was referred to Dr. Castro. That's what she's saying.
That's not why she was referred to Dr. Castro, and I think you need to look no further than Dr. Burke's chart. She complained of congestion and postnasal drip. If she complained of loss in taste and smell, she would have been back with Dr. Shafee for an ENT referral, not an allergist. So here you have the deposition testimony of Dr. Burke, wherein he says, I always ask a patient about taste and smell. She was within normal limits in September 2014, but she did complain of allergy symptoms, so he prudently sent her to an allergist, just like 2 years prior, he sent her to an ENT.
Let me say this. So I want to make, many times I ask a question so you understand that we understand. How's that?
Sounds good.
If I understand your position, this is your position, that on August 13th, when she presented to Dr. Burke complaining of loss in taste and smell, he referred her to Chaffee, to the ENT.
That's correct.
He discharged his duty when he did that.
He discharged his duty, and he also did obtain, contrary to what the plaintiff has said, he obtained a non-serious etiology and diagnosis by learning that it was a deviated septum, which gets gravely underlooked by the plaintiff, yes.
And then roughly 2 years later, when she comes back, that didn't change the discharging of the duty. And that therefore, he hasn't deviated and there's no liability.
he hasn't deviated because he at all times in the first instance, and I don't mean to harp on duty, but I think it's important to remember at every turn here that you don't get to the question of standard of care if it's something outside the bounds of what the limited legal
In other
duty.
words, you discharge your duty when you refer out, and he did that in August, and game over.
Correct. And if I may, Your Honor, one more point with regard to the September 2014 visit. Something that also should be pointed out is in the interim period, that 24-month period plus when she decided to cease treatment with her primary care provider and instead see a naturalist and an acupuncturist, there's also records in the record from the Princeton Longevity Group and one other provider that's escaping me right now. She didn't complain of any nose or throat problems, loss of taste and smell during that treatment either. And I would point the court to pages 640, 654 through 58, and 679 of the record. She didn't have any loss of taste or smell problems within that 2-year period.
But she did complain to Dr. Castro just a few weeks after seeing Dr. Brown. She did make that complaint to Dr. Castro.
She might have complained to Dr. Castro, but that has no bearing on Dr. Burke, because Dr. Burke has previously saw her, and there were no complaints of that.
Counsel, you should begin to wrap up.
Your Honor, for the foregoing reasons, namely that there is no duty on the part of Dr. Burke to have done the things that the plaintiff said he should have done, as well as his compliance with the standard of care, we respectfully submit that this court reverse the lower court's ruling and grant Dr. Burke's motion for summary judgment. Thank you.
Counsel.
May it please the court. The plaintiff in this case saw Dr. Burke, was referred to Dr. Chafee. Dr. Chafee reported back to Dr. Burke with several letters, and nowhere in those letters does Dr. Chafee say, I have an explanation for her loss of taste and smell. Moreover, he writes to Dr. Burke and says to Dr. Burke she didn't show up for an appointment. Well, then she does go to see him in January of 2013. And Dr. Chafee at that point, and it's in the record and it's undisputed, records that he thinks she should have a MRI. Now, I'm not sure, I've read the case law, and let me say this with all due respect, doing this type of work for my lifetime, many of these cases have their own DNA. And I'm not sure that you mean, in terms of your decisional law, that a doctor who has, in this factual situation, sent a patient out to an expert, then doesn't have a duty to inquire when that patient next presents.
Yeah, this has got some
the
trimmings. In other words, the easy case is the real specialist that's totally out of it. And then the easy case on the other end is the send out for some testing. This seems to land somewhere in between, and we do recognize that.
Okay, and so I won't belabor it. Let me say, though, in defense of Judge Clark, because I think her decision has been somewhat unfairly characterized here, Judge Clark found, and it's on page 16 of the record, with regard to Dr. Castro, that Dr. Castro thought a complete evaluation was necessary, a comprehensive evaluation was necessary. And Dr. Castro wrote in her record, I recommended that a complete evaluation was necessary. Now, an internist, a family practitioner, virtually any specialist referring to Dr. Castro would be able to give an opinion, as the expert in this case did, that I expect to hear back from that doctor. That doctor thinks there should be a comprehensive examination. The duty and the standard of care is to respond by giving me notice that I need to do a comprehensive examination. Now, factually, Dr. Burke is now seeing the patient again 3 more times. And our expert's affidavit, I think, is clear that the standard of care for a comprehensive examination would have been ophthalmoscopic examination, which was not done. Any questions?
No questions, Counsel.
Thank you so much.
Thank you. Case 850, Gamblin versus Nam.
You are recused?
I'm going to recuse him.
Okay. Justice Wyman is recused on this matter.
Yes. May it please the court, Brittany Pemberthy on behalf of plaintiff appellant, also respondent. This case involves a motor vehicle accident.
Just so I have it, I'm sorry.
Pardon me?
Tiffany D'Angelo for defendant.
You were actually the first moving party. Oh, sorry. It said submitted, I apologize.
Yeah, I thought your case was submitted.
Mr. Durkin was the attorney of record, and he notified the appellate division that I was substituting for him.
Oh, okay.
I apologize for that error. I'm sorry.
Okay, go ahead.
Good morning, Your Honors. First matter that we were addressing was the granting of plaintiff.
Let me get the geography correct
Sure.
in my brain. This is where I was going to go a second ago. But this is the entrance ramp off of Transit Road, correct?
Yes.
So, because I sometimes take that coming from here, I'll get off and go at Transit Road, and there's a big circle coming off, and the same thing coming on heading west.
Correct, Your Honor.
Okay, so these two cars that are involved here, they're going to get on the thruway west, but they're on the on-ramp, so to speak, on that circle. And they both slide off towards a ditch, embankment, whatever the trooper called it, right?
Yes, Your Honor,
Okay,
that's
got
my
it.
understanding. And defendant's motion for summary judgment and was stating that based on the emergency doctrine, there was no negligence on the part of the driver. And
You moved affirmatively on the emergency doctrine, correct?
we did, and then we're also appealing Judge Sywick's decision granting plaintiff's partial summary judgment on the finding of
But
negligence.
do you really think the emergency doctrine applies here? I mean, it's not like you had any choice, any options, whatever, not necessarily that's a key to the doctrine, but, I mean, here, you just slid off the road because there was ice or snow.
Our contention, Your Honor, is that it was an unexpected emergency. The defendant did not have any problems with the weather or the road conditions leading up to the accident, nor did the plaintiff's vehicle. Both parties testified that that ice that caused the plaintiff's vehicle to slide into the ditch and then subsequently caused defendant to rear-end the plaintiff in that ditch was unexpected. There were no other black ice on that road leading up to the accident.
If, as a matter of law, you don't have the emergency doctrine, but more so, if, as a matter of law, you do not have a non-negligent explanation for this accident. Just hear me out.
I'm sorry.
So that seems to be what the court concluded, right? Saying you don't have an emergency defense and you don't have a non-negligent explanation, therefore you're negligent. Is it your point that when you go to trial, that the plaintiff must similarly be negligent as a matter of law?
Our point, Your Honor, is that Judge Sywick conflated the two different concepts. That the well-settled law holds that a defendant can defeat a motion for summary judgment for a rear-end accident, showing a non-negligent explanation. Here, that sudden black ice, when the defendant was going under the speed limit, hit the ice, pumped her brakes, she did everything acting reasonably, would create a question of fact for plaintiff's motion.
But your client knew there was heavy snow. Doesn't that give reason to anticipate a slippery, curvy road?
Snow versus ice, though, she didn't have any, she testified clearly in her deposition, she did not have any problems with slipping, skidding, sliding at any point prior to the exact point of the accident. And therefore, we contend that there was a non-negligent explanation for that rear-end accident.
And of course, your point would be you don't even need to establish that as a matter of law. There's just a triable question of fact on negligence.
With respect to plaintiff's motion, yes.
Okay.
And then, in contrast as well, the defendant cross-moved, asserting that the emergency doctrine based on the points that I just made about the actions leading up to the point of the accident. With respect to the motion in plaintiff's cross appeal for the summary judgment, we contend that the trial court did make the correct decision there, dismissing the permanency cause of action as the chiropractor affidavit clearly stated there's no findings of permanency. And with respect to the 9180
and significant limitation. There were numerous questions of fact that would have precluded the award of summary judgment on those two categories based on plaintiff's own medical records, the lack of objective findings in the medical records, and also the affirmation of our radiologist, Dr. Detier, who plaintiff raised for the first time on appeal that that's improper, which the settled case law in this department holds. We do not need to have an actual doctor examining to defeat a motion for summary judgment.
Thank you.
Thank you, Your Honors.
As Justice Curran had pointed out, this is a motor vehicle accident in which the plaintiff was already in a disabled, stopped vehicle on the side of the roadway.
Similarly negligent as the defendant.
You could say she's negligent, sir, but there were no injuries sustained in that removal from the roadway by the operator of plaintiff's vehicle.
And comparative faults for another day, I get that.
Correct.
But if you say that the defendant did not, as a matter of law, have a non-negligent explanation because she didn't anticipate, or she should have anticipated the icy condition because of the heavy snow, the same would be true for your client.
It's not to say that the operator of plaintiff's vehicle wasn't perhaps also negligent, but that doesn't have anything to do with the instant case. The defendant has failed to come forward to this court with any non-negligent explanation with regards to the accident here. The defendant failed to operate her vehicle at a safe rate of speed and under proper control, considering the weather conditions.
I was looking at PJI 2:82, which is the operative charge on this, and it does have the word unanticipated in it. And then looking at some of the cases there's one written by Judge Dillon from the Second Department that talks about an icy road, not a snow-covered road, is an unanticipated condition that can warrant that charge.
Well,
Isn't that what we have here?
No, not necessarily, Your Honor. I would point, Your Honor, to the First Department's case of Williams v. Condrey, in which they say slipping on ice is an inadequate, non-negligent explanation. So because the defendant was aware of the weather conditions being so poor, she testified to the moment she left her house until the happening of the accident, she knew the weather conditions were not appropriate.
Here's my ultimate question for me on this issue. Does that mean that every time there's heavy snow in western New York,
Rarely.
it deprives someone of the ability to claim there's a non-negligent explanation? Because you should have anticipated that you might slide off the road no matter what speed you're at, no matter the curviness of that turn, no matter what, you should have anticipated it because there was heavy snow. Is that the argument?
Well, certainly, Your Honor, if it was unanticipated, certainly if, as Your Honor I'm sure is aware, traveling to Western New York, suddenly it's, sunny, and then all of a sudden we have blizzard-like conditions. That would be...
That's not the case here.
That is not the case here, not at all. No, she knew from the start of her trip that the weather was not appropriate. There is a specific clause in the VTL that allows officers to cite people that even though you're traveling at the regular rate of speed, the appropriate rate of speed, that you can actually be cited for not operating your vehicle at the appropriate rate of speed considering the weather conditions, which is exactly what is here. Obviously, the defendant wasn't cited in this, but I'm giving you an example that certainly we have a duty as a safe driver to consider the conditions of the roadway.
Section 1112 or something like that.
Oh, you're good, Judge, yes.
Somewhere in there. Would you take me at least to the serious injury issues? And I don't think we need a lot on it because we get a lot of these cases, but what's your position?
Yes, your court is obviously very aware of summary judgment and moving for summary judgment under the serious injury threshold. Here, with regards to plaintiff, our arguments were that the lower court erred in denying summary judgment to the plaintiff. There was objective medical evidence of plaintiff's serious injuries without any issue of fact having been raised. There were multiple affirmations and affidavits of plaintiff's treating providers that were provided in support of plaintiff's motion. Just as in Skamaka v. Bennett, her injury doesn't need to be total or permanent to qualify for recovery under the law, under Insurance Law 5102. Here, there was significant limitations to her neck, to her back, and it impaired, most importantly, it impaired her ability to return to work for greater than 2 years. So for 2 years post-accident, this plaintiff had injuries related to the accident that precluded her from returning to work. The lower court should have considered the duration of plaintiff's injury, and our argument is that simply they did not. Plaintiff treated with her chiropractor for 11 months post-accident with injuries.
We know the record very well, but you would say at a minimum, you get to go to trial on this.
at a minimum, I would get to go to trial, but I think that plaintiff qualifies. She has injuries that qualify for summary judgment. I don't need to go to trial and try to argue summary judgment. I think that she's met the threshold for summary judgment with regards to serious injury, minimally being the 90-180. Somebody disabled from their employment for at least 2 years from injuries related to an accident, and coupled with, obviously, the testimony, unrebutted, of her daily limitations being sleeping, cooking, caring for her children.
And again, we're very familiar with the record.
More than qualifies for her recovery. Thank you so much, Your Honors.
Thank you.
Case 852, City of Utica versus Millette.
Good
Proceed,
morning.
counsel.
Good morning, Justice Whalen, distinguished members of the bench. My name is Scott Carson. I represent Michelle Millette through the auspices of the University of Buffalo School of Law Pro Bono Appeals Program. May it please the court, I will presume that the court has a thorough knowledge of the facts and will not recite them here. The key issue that we press in this court is that the City of Utica failed to sustain its burden of proving that the court had a lawful basis for exercising in personam jurisdiction over Ms. Millette. And the law there is fairly clear, and it's derived through the case of Williams versus B. Miller, which was decided by this court and then affirmed by the Court of Appeals, that it's a two-pronged test and that both prongs must be satisfied. First, that the exercise of in personam jurisdiction must comport with CPLR 302, in this case 302A1, New York's long-arm statute, which provides in pertinent part that the party upon whom jurisdiction is being pressed must have contracted anywhere to supply goods or services in the state. The second and also essential component of the test is that the exercise of in personam jurisdiction must comport with the Due Process Clause of the U.S. Constitution, which in turn has two elements as well. First, that the non-domiciliary, in this case Ms. Millette, must have minimum contacts demonstrating that she purposefully, and purposefully is a key word here, availed herself of the privilege of conducting activities in the forum state and invoked the benefits of doing so, making it reasonable for her to anticipate
Mr. Carson?
that she would believe.
Mr. Carson?
Yes.
Let's take that law and put it to work here on the facts.
Okay.
So the other side will say to you, well, wait a second, she signed a guarantee. Okay, that may not be enough. She probably signed in Connecticut, maybe New York, whatever. But in addition, there's that bulletin, whatever, the document that came out that touted your client's experience, business background, and it's showing her as a key member of the development team. And then in addition, the record reflects that a development officer testified that she was very involved in meetings. She was there in New York. She was part of the development team, and she discussed it. And we have nothing really to the contrary from your client. So it seems to me, isn't that enough to transact business, constitute minimum contacts, and it certainly has a nexus to what happened here, that is the execution of the guarantee.
Well, thank you for the question, Justice Curran. I respectfully disagree with your conclusion that my client presented nothing to the
I'm not at a
contrary.
conclusion yet, Mr. Carson. I just
Okay.
want to get the other side and hear your reaction to it.
Very good. Yes, to be sure, there was a Mr. Spaeth who presented an affidavit on behalf of the city who said that she made some visits to Utica and she participated in several meetings. We maintain that those allegations were quite vague and that
Mr.
she
Carson, let me
did.
ask you a question. If if we take those allegations that you're citing to, Mr. Space allegations, as true, are they enough? I mean, doesn't the affidavit talk about her engaging in conversation and being there, boots on the ground, at the building on a regular, not a regular basis, but periodically? I mean, isn't that enough?
I can't disagree with that conclusion, but I don't think that that conclusion flows from the testimony, because she specifically alleged that she spent a total of 20 hours over the entirety of 3 years in Utica, and that she did so primarily for the purpose of providing her former husband, who was intimately involved in the development project, with some visitation with their children. And it was just, most of that time was spent at a hotel room because it was nighttime and she could not physically make the 300-mile trip back to Connecticut where she lived. But she uncategorically and specifically denies that she had any involvement in the project. She denies that, she says that it was her husband who, without her knowledge, presented her as a member of the development team. And the fact is that she denied it specifically and uncategorically. So I think in this case, this court is not bound by the factual determination of the trial judge. Your power to determine the facts is coextensive with those of the trial judge. In this case, the allegations that she was participating in the development project are simply outweighed by the allegations that she presented that it would have been impossible. Here she is in 300 miles away as a single parent, impoverished, trying to raise 3 developmentally challenged children, and the idea that she could have been making trips back and forth to Utica, other than that narrow 20-hour window over 3 years, which was attributable not to the development project, but attributable to something else, is simply nonsensical. So we urge this court to take a hard look at that.
We'll take a hard look at that.
But, because I think you have the power to make a contrary finding that is more consistent with the evidence. But I want to go back to the word purposefully, because in the test, under the due process clause, there needs to be a finding that in order for jurisdiction to be exercised, in personam jurisdiction, under the long-arm provisions and under the Constitution, there needs to be a purposeful intent to submit to the jurisdiction of the New York courts. In this case, my client specifically rejected that, and I don't see how you can get around the fact that she wrote into that guarantee that the sole forum, the sole venue for determination of any dispute that might arise under the guarantee was what existed, what she wrote into it, which said that all disputes shall be determined.
Is there any evidence that everyone agreed to that? Or is that
Well,
simply?
There's evidence that she agreed to it.
Well, I know, but how about the other side?
Well,
Doesn't that seems to me it would defeat the entire purpose of a personal guarantee.
Well,
why would the city agree to that?
I don't know that the city would agree to it,
Well,
but
I don't know that they did agree to it.
it certainly vividly illustrates her intention, which in terms of determining long-arm jurisdiction is that.
Did the city initial that and accept
No,
that?
I'm not claiming that they did, Your Honor. I'm saying that for purposes of
Mr. Carson,
ascertaining her intention.
Counsel, are you limiting your argument in this regard in that it was dated, it's a handwritten note, and that went to your client's mindset? Is that really why you're pointing out the handwritten language?
Well, if I understand your question correctly, Presiding Justice Whelan, my position is that in order for a court to exercise long-arm jurisdiction, there must have been a purposeful decision to avail oneself of the privilege of conducting business in New York. In this case, The
But doesn't
finding, that
but
finding is
Mr.
belied.
Mr. Carson, doesn't that document in a way cut both ways? Sure, maybe she's trying to stay out of New York, but it shows how purposeful her behavior was with respect to that guarantee and her involvement in it. Doesn't it have another side to it? I mean, do you really need that point to make your point that, hey, she says she wasn't here, she was here for 20 minutes, whatever it was, 20 days, and she was
20
only here to
hours.
take care of the children? Do you really need that notation? That's a little suspect, some would argue. So
I think-
your argument's the same no matter what, right?
I think my argument goes beyond that point, but I think that is terribly illustrative of what it is I'm arguing, which is that she did not have an intention to, a critical intention and a necessary intention to submit to
A
the...
purposeful intention.
A purposeful, well, I'm trying to come up with as many other words as I could to
Okay.
describe that.
Well, I think we understand that argument, Mr. Carson.
Okay, I'll rest on my brief as to the other points, but obviously, there were 3 grounds upon which Ms. Millett moved to vacate the default. I've only addressed the jurisdictional ground. There was also excusable default and misrepresentation on the part of the city, which I will rely on my brief to allow the court to consider.
Thank you, counsel.
Good morning, Your Honor. Armin Festine for the City of Utica. Very briefly, just a couple simple points, and I'll rely on my brief, but Honorable Justice DeJoseph kind of stole my thunder with the comment that he made to the effect that no rational creditor, especially an institutional creditor, would accept a personal guarantee with the type of language that the appellant alleges was placed on it, because that completely undermines the purpose of the guarantee. If purpose of the guarantee is to provide the creditor with another avenue of recovery if the primary obligor goes broke, bankrupt, or the collateral loses value, which is pretty much what happened here. Secondly, all of these issues about
Well, the
guarantee...
limitations on the guarantee, to the extent that they were limitations, if I remember correctly, were essentially, you have to exhaust your other remedy, in others, in terms of your other sources of collection before you come to me, and if you come to me, you have to do it, you know, in Connecticut, right? So I mean, it doesn't frustrate the ability to go after, it just places limitations on when you can do it and where you can do it.
Yes, and those limitations, I would argue, would be extremely cumbersome to the point where it would really nullify any benefit of the guarantee. But the excusable default argument has to be made within a year. The application clearly wasn't.
But is Mr. I'm sorry, go ahead.
I'm sorry.
You know, I'm having a hard time finding where there was any proof of the judgment being served with notice of entry.
The judgment was served with notice of entry at the same time that an application was made for alternative service on the appellant before Judge Clark, because the city attempted to enforce its judgment by the service of an information subpoena.
Yeah, we know that the judgment was served, but we don't know that it was served with notice of entry.
I believe it was included in that packet that was served by alternative means per order of Judge Clark after application.
Okay.
Yeah. This case kind of takes one back to Civil Procedure 101 and in personam jurisdiction in Pennoyer versus Neff through International Shoe right on up, and CPLR 302 is the codification of that constitutional law. And it basically states that if one has even a limited number of contacts, a non-domiciliary has even a limited number of contacts with a particular state, but the cause of action is related to those contacts, personal jurisdiction is established. And in this case, this development was ongoing since 2008. It did not completely fail until
Mr. Festine,
2014.
Real
Yes, sir.
quick, just to knock this out of the air, but you can't really rely on whether she owned real property somewhere else or whether she had a job in New York City, because there's got to be that nexus between the contacts and the transaction. And you would rely on the affidavit from that gentleman, Mr. Spieth, whatever, and the pamphlet that was distributed, that's really the crux of your argument on the facts. Do I have it?
I would agree, Your Honor.
Okay.
I would agree. It's not, she did own, according to her responses on the information subpoena, she did indicate that she owned some property down in Deposit, New York, but I don't know when. Yeah. And no, I mean, the commuting, a lot of people commute into New York City. I get that. I understand. But beyond that, if the court has any questions, I'll rest on my brief.
No questions, counsel. Thank you.
Thank you very much.
Case 853, Webster Citizens for Appropriate Land Use, Inc. versus Town of Webster.
Good morning, Your Honors. May the
If you
court
can wait
please...
just 1 second, counsel, till your opponent gets situated. No, that's quite all right. Very good. Thank you. Counsel, proceed.
Good morning, Your Honors. May the court please Charles Genesi, Town Attorney for the Town of Webster, the appellant in this matter. You have my brief, and I'm not going to repeat what is in there. What I do want to emphasize to the court, however, is that my take on this, and I'm hoping that the court will agree, is that this effectively was nothing more than a preliminary injunction attempt by other means, and that if the law as used here continues to be applied, and it's going to have dramatic effects throughout the state. It will not be just a local matter.
Sir, my question here is this. You're basically taking the position that just to use a slang expression, the DPW never pulled the trigger here because they never made a finding
Correct.
regarding zoning.
Correct.
And I understand that argument. On the other hand, the Department of Public Works did issue a lengthy memo dated October 28th. They made several revisions to the plan. Why would they conduct that study and make all those recommendations if the property was not a permitted use?
Because obviously they assumed that it was a permitted use.
But they didn't make that explicit
No,
determination.
that's correct. They did not. We had actually a matter, also the same attorneys represented the opponents, involving another hydroponic plant years before, for a tomato plant. It was the integral matter. And at that point, we had numerous memos from the State Department of Agriculture and other experts saying that basically this was a proper use. So it was not something that we considered would have been an issue.
Okay.
In any event, my concern here, Your Honors, is that and obviously this is on the court because the court can issue a decision clarifying the matter, but I think what we're going to have happen is that there's a dearth of case law here. What could possibly happen is people with or without standing, and I'm not arguing the standing issue here. I think these people had standing to bring some sort of a matter, but the fact of the matter is that anybody, on anybody's behalf, can bring this type of proceeding seeking an interpretation of something in the zoning law for some particular development they don't like at any time, and then stay the proceeding until that matter is resolved. My opponent raised a matter that they had done one prior attempt before, which was true, in May of 2019. However, that matter was tabled numerous times, and the request was ultimately withdrawn, so that matter was never resolved. And I could also throw in anecdotally that I have been a zoning board member, not attorney, but I've been a zoning board member. I was for 6.5 years at Webster. I never recall any request for this type of a matter from a non-applicant coming in before.
Let me ask you this. It was the deputy town attorney who made the determination that there was no standing here.
Yes.
Shouldn't that determination have been made by the ZBA? How does the deputy town attorney have that authority?
By the DEA, Your Honor?
No, yeah, shouldn't the ZBA have said?
Oh, the
once they
ZBA,
got
I'm sorry.
Shouldn't the ZBA have said we don't have authority? Why would the deputy town attorney have that power?
Well, I guess he was speaking on behalf of the ZBA, Your Honor. That's all I can say. I can't answer that, whether or not he went to them, so.
Any further, counsel?
No.
Anything? Thank you.
Good morning, Your Honors. John Tantillo, Knopf Shaw for Petitioner Appellate, Webster Citizens for Appropriate Land Use. I want to just briefly address the suggestion that this decision could have dramatic effects throughout the state. This is settled law. This is a routine practice. Town Law 267A4 states in no uncertain terms that an appeal may be taken to the ZBA by any person aggrieved by any order, requirement, decision, interpretation, or determination made by the administrative official charged with the enforcement.
That's the catch here, isn't it? Was that determination made? And in this case, it has to be made by the Department of Public Works.
Well, that's what a lot of case law says, and that's what the town's own code says. The code specifically says that.
But did the DPW make that determination?
Yes, I think the memo that you referenced, the memo that you referenced does say. So the code says the DPW is to look at any application and then determine at that review if any variances are needed. Determining if variances are needed is determining code compliance. If they say that no use variances are needed, they're saying that it's a permitted use. So this application then being referred to the planning board is a determination by the DPW that it's a permitted use in the town of Webster. And in fact, that determination was reflected in the agenda for the town planning board meeting, which stated, very unequivocally, this is a permitted use in the town of Webster.
The town planning board said it in their notice.
Well, the town planning board doesn't.
But did the Department of Public Works ever say it?
Well, the town planning board doesn't draft the notices. I think actually DPW drafts the notices for the planning board. And in fact, the court below picked up on this when Justice Donofrio said either an interpretation was made by code enforcement, which could then be appealed, or the planning board made the interpretation itself, which is unlawful. It's settled law in the state of New York that planning boards cannot interpret zoning ordinances. So, even if no interpretation was made, although we think those documents show that one was made, the conduct was still unlawful because the planning board has no authority to make the interpretation itself.
Right.
And so the judge below gave two different reasons for.
But isn't the first hurdle here is that the determination has to be made by the Department of Public Works?
That's one of the two ways that the court below found that the conduct was or should be annulled.
All right, but that, and I don't see any place in this record where the Department of Public Works made this explicit finding. You're suggesting their finding was implicit in their October 28th memo.
Well, I think the planning board agenda, the judge below did find that the planning board agenda was a finding that could be appealed.
I know, but was that a correct finding? Just
Yes.
because the planning board said it. Did the Department of Public Works say it?
Well, I guess I would ask if that's the case, then how could aggrieved parties ever kind of get their issues before the court in this instance? Would a way to insulate any zoning compliance reviews from a ZBA or appellate review be just to not issue the decision? I mean, it had to have been reviewed before.
Well, is there a remedy there for somebody if the Department of Public Works isn't issuing a decision? Can they go to court and require?
Well, if they didn't issue a decision, then I guess essentially the planning board would be making the decision, which would then be another ground to annul the decision as the court found here. So it's covered on both prongs. Whether or not, if they did make the decision, then our appeal should have been heard. If they didn't make the decision, then the planning board approval was correctly annulled as outside of their authority to make. Someone's got to decide this thing complies with the code. And in either instance, the town acted unlawfully here.
Anything further, Counsel?
I do want to address the suggestion that this is being used as a stay, so that they're trying to use the automatic stay. We did point out in our brief that the automatic stay was not triggered here. The automatic stay was not issued in the decision of the court below. And in fact, in the subsequent decision that Justice Donofrio issued, she explicitly pointed out that the automatic stay was not triggered. So the suggestion this is somehow a backdoor preliminary injunction motion is refuted by the record of the case.
Thank you, Counsel.
Thank you.
Case 845 and 846, Unger versus Ganchi.
May it please the court.
Let's wait, Counsel, let's wait till your opponent's situated, please. Counsel, proceed.
Thank you, I didn't see him, Your Honor. May it please the court, I'm Stephen Halpern, counsel for Bernard Unger, the plaintiff in this case. This appeal involves the interpretation of a buyout contract. The contract governed the sale of a financial services.
You know, as you know, this has been here before, and we understand the facts.
Yes.
So, as I understand your arguments today, you're saying the court erred in dismissing your breach of contract claim. It's really a question of timing. Who breached? And who breached first in any event? I know that there's some debate over that, but as I understand your arguments, you're saying we already decided that the mere operation of the business, financial business, wasn't a breach. And even if that isn't the case, the defendant can't prevail because he can't establish damages. Personally, I'm not so concerned about the rescission. I'm not certain this is a rescission type case. So if you want to be heard on those two, I think those are the two highlights of your argument.
Yeah, I'll deal with rescission first. I couldn't agree with you more, Justice Carney.
Yeah, I don't need to hear about rescission.
Okay, that's great. Then let's talk about the question of a breach. In our view, Mr. Unger performed fully on October 1, 2010, when he transferred over 200 accounts worth $21.7 million to Mr. Gansey. And ever since that date, now going on almost 11 years actually, in a week or so, Mr. Gansey has had the benefit of that bargain, the financial benefit of that bargain. He's had the opportunity to service those clients, to generate fees, and to earn, I might say, a handsome living. By contrast, we have a client here who was entitled under the terms of the buyout to $500,000 paid in $25,000 installments per quarter. To date, he's received a little more than half of that. He's out, what, $225,000, we would say. And in terms of whether Mr. Unger breached, I think there's an important chronology for the court to appreciate.
Mr. Halpern?
Yes.
But don't you have to establish that your client did not breach?
Yes, and we don't believe that he did, Your Honor.
Okay. But if we concluded the contrary, he can't collect the $225. Is that the law?
If you conclude based on these facts that he breached, I suspect that you're right, Your Honor. But if I may speak to what happened at trial, it's clear that Mr. Gansey missed at least 2 payments.
Okay, so let's, I know there's some confusion about when it was due, but let's take your date. You say that the next payment that he owed was due on July 15th, 2013.
Or possibly even April, I would say.
Okay.
And in previous years, I might point out, Justice Carney, that Mr. Gansey had made payments in July of 2011, in October of 2011, and again in July and October of 2012.
As I understand it, your position is that your client fulfilled his obligations under this contract, and on the other hand, the defendant did not make payments.
Yeah, I would just emphasize this, Justice Carney, that this, to my mind at least, is a question of the legal interpretation of the contract. And I think in that regard, the trial judge made an error. At the very last page of the trial judge's opinion, page 6, he notes that, and this is a quote, not my phrase, the main purpose of the agreement, close quote, was to prohibit Mr. Unger from competing. I think there is a misreading of the contract, a clear misreading of the contract. The headline, before any of the language of the contract was written, was 21st Century Buyout Agreement. This was about a buyout agreement.
Yeah, and that's why you started your argument today with all the great things that were transferred, the business.
That's correct,
Yeah.
which to this day, as I say, Mr. Gansey has been able to enjoy it. So our view is, as of October 1, for that matter, he fully complied. with all of his obligations. I will say this about the chronology. I want to make sure I get this out. The evidence at trial established that the only time that Mr. Unger reached out to former clients was in January of 2014. That's an important date. I say that's an important date because it is also true in the record, there's no factual dispute about this. There was no payment made in April of 2013, no payment made in July of 2013, no payment made in October of 2013. So by the time January of 2014 rolls around, it's our view that the facts are clear here. They're not in dispute. Mr. Unger was relieved of any further obligation he had under the contract and therefore was free to contact former clients. And one additional caveat, if I may. The final outcome of the damages trial, of course, was that there were no damages. I mean, the clear implication of that is whatever Mr. Unger may or may not have done, it did not result in any damages that Mr. Gansey could show at trial. And I would point out as well that opposing counsel hasn't appealed that determination. I guess they concede the point that there were no damages.
A little bit of an argument with the nominal damages, but that wasn't raised.
That was not raised. That's right, Your Honor. And so I must say, in preparing for this oral argument, I thought a good deal about the equities in this situation. It seems to me we've got one person who walked away from the deal with everything he bargained for to this day, and another person who thought he had a deal, and 11 years later is still out $225,000.
It's like a law school question. This is some heavy contract law. So
I think so, but if you accept the facts at trial, that there was no action taken by Mr. Unger until January 2014, then I think you could say having been in a situation where 2 or 3 quarterly payments were missed, he was free to contact former clients.
We'll take a hard look at that, Mr. Alpert. Anything further?
No, I thank you for your time, Your Honor.
Thank you.
Thank you.
Mr. Burke, do you have a coat?
Yeah, I do, Your Honors. I appreciate, first of all, letting me argue last. I contacted the court having a little bit of difficulty, which was unexpected, with some outpatient surgery. In fact, I had to get a ride here from my wife, and I'm having difficulty putting on and keeping on the coat.
Well, we'll excuse that this time.
Thank you, Judge.
Mr. Burke.
I apologize. Your Honors.
Is counsel's chronology correct?
No.
What's your version?
My version, respectfully, Judge, is reflected in the record. The timing of this was confirmed at trial. The first confirmed and admitted targeted solicitation of Mr. Gansey's clients by Mr. Unger occurred at the latest in May of 2013.
Yeah, so that's important for us because the idea that a non-breaching party is relieved from performance, if we look at whether it's a material breach, but in other words, your position is that the plaintiff breached it, and then therefore your client no longer had any obligation to perform or make those payments in, let's even call it July of 13, because their breach was before that. Is that?
That would be an acceptable argument, Judge. I would argue that the chronology and simple math, applying the $25,000 per quarter over the period of the 20 quarter payments, would take us at least to December of 2013. Where he was paid.
I know you do argue that, and that's a little bit complicated, and we're looking at what happened below. But that's why I suggested that at best case scenario, opposing counsel, as I thought, now it says April, but I thought he had suggested the plaintiff's argument was the payment that was due that wasn't paid was July 15th.
Yes, and I appreciate that question, Judge, and I embrace your request for me to delve into the facts because I think the facts and the equities are heavily in my client's favor. We know for a fact in the record, and the site is record page 266, that the first time that we've confirmed that Mr. Unger invited clients of Mr. Gansey to his seminars for the purpose of soliciting their business was February of 2013. So February of 2013 is the first point that we have any written indicia in the record of a breach or an intention to breach. We'd argue it's actually breach. There was a further solicitation which Mr. Unger admitted was targeted at mutual clients or his former clients for an April 2013 seminar, and the sites in the record there are record 177, 182, and 237. The next documented breach, which is in the record, is May 9, 2013, where there was yet another event. This was a lunch or a dinner event seminar, where Mr. Unger admitted at record page 285 that he targeted these mailings and that these mailings were not just general solicitations or were purchased through some third-party marketing agency. The big one, of course, Judge, is record page 50, the Do Not Be Afraid email on July 24th, 2013. This is where the appellant unequivocally tells my client that there is no way he is going to honor the restrictive covenants set forth in that agreement. The exact quote is Mr. Unger talking to my client, "New York law is loath to enforce these things," meaning the non-solicitation agreement, "under any circumstances, but will definitely not enforce it when there is no time frame. Any attorney who knows the first thing about contract law will confirm this with you." Now, it's interesting to note that up to this point in July 24th, 2013, Mr. Unger had never mentioned to Mr. Gansey that Mr. Gansey was late or that there was any breach of the agreement. This is the first direct contact from Mr. Unger to Mr. Gansey since Mr. Unger purportedly transferred his book of business. So Mr. Unger continued to contact directly Mr. Gansey's clients for the remainder of the year. He upped his efforts following July 24th of 2013. He told Mr. Gansey he intended to do so. He told him that the agreement...
Yeah, and we're looking at this in a light of what the lower court did under the Thorson versus Penthouse standard. In other words, the decision of the fact-finding court shouldn't be disturbed unless, on appeal, unless it's obvious that the court's conclusions can't be reached on any fair interpretation of the evidence.
I think that's the right standard, Judge.
You know, I know that this is very fact-specific and you want to march through all the facts, but we've read the record, and as I understand your argument, the court got it right with, or the court, at least from our review, it should be that they breached first, relieved you because it was a material breach of any duty to perform, and any missed payment was after the breach of the agreement.
That is succinctly and correctly put, Your Honor. If I can turn to the actual contract language, and frankly and candidly, I prepared to come to this argument expecting my opponent, who I have tremendous respect for, and we get along with great, I expected him to run from the facts. I was surprised that he turned to the facts first. That's why I addressed the facts. Turning to the law, I think the law is very clear. The contract could not be more clear on this point. The contract, as you know, is set forth at record page 30 and 31. At page 31 of the record, it says, Unger agrees not to compete with Gansey, nor will he solicit business or services from their immediate clients with the intent of selling investments or promoting other business services. Respectfully, Mr. Unger admitted he did this, and he admitted he targeted clients going all the way back into February of 2013. It's undisputable. The math on how far our payments go forward into 2013, you know, if you take my extension to its logical conclusion, we actually got into 2 grace periods, which would get us into 2014. But under no interpretation of the facts does Unger dispute that he was specifically targeting clients. It definitely, as my worthy opponent has noted, definitely in early 2014. But Mr. Unger himself admitted that he was doing it well into 2013. And to accept the appellant's version of the contract as being clear or unambiguous, it simply defies logic. What my opponent is asking this court to accept is that Mr. Unger had completely discharged his duties the moment he transferred that initial book of business to my client in 2010. That cannot be what the contract means. He cannot simply have said, here are my clients, and then begun to solicit those clients back. To accept their interpretation of the contract Mr. Unger would pretty much be able to do whatever he wanted in terms of soliciting Mr. Gansey's client until he received the $500,000 of the transfer.
Well, that goes to whether it's a material term, so we understand that.
Thank you, Judge. I'm
Anything
happy-
further, counsel?
No, judges. And again, I thank you for your indulgence. I'm a little embarrassed at this state of my appearance today.
Not a problem, counsel. Thank
very
you.
much.
And the mayor,
Case 853.1, McClay versus DePasquale. I am recused from this argument. Not a problem.
Good afternoon, Your Honors. Jessica Culpit on behalf of the petitioner, Darlene McClay. That's a great start. Sorry. Very simply, we are here requesting this court invalidate the independent nominating petition, United for Amherst, as it failed to bring forward the requisite number of valid signatures to appear on the ballot. That's 750. The law is clear. Handprint, and I would handprint lines, because they're not signatures, are not permissible. It's direct in the...
except didn't we have affidavits that cured that?
I would say they absolutely do not cure that. So to go to the next point, if we look at the affidavit submitted, one, I would submit to Your Honors, those shouldn't have been accepted. Specific objections were filed in this case on May 27th. The parties were well aware of what our issues were. The hearing was not until July 27th, 2 months later. At 6 a.m., affidavits are uploaded. Even if the court were to say, we accept these affidavits, I submit you should not. I submit we have the opportunity to cross-examine on each of these individuals. But even if you were to allow these affidavits, they're not sufficient. They failed to identify a page, a line. They signify in those affidavits, and I would draw your attention to the record beginning at 458. A copy of the United for Amherst independent nominating petition that I signed was brought before me. Where is it? It's not attached as Exhibit A. It's not before the court on what it identifies. It identifies a person somewhere within the over 1,000 signatures got on the hours before and then purposely, maybe, sloppily, perhaps, submitted mere seconds, and it's hours, before the hearing were to occur. At that point, testimony of those persons should have happened, and they had the opportunity to do so. The court, in allowing for these affidavits or determining that those were quote-unquote signatures, cites Hennessy. What it failed to leave out is Hennessy relied on the testimony of the signers. It relied on the testimony of the subscribing witnesses. So the fact that affidavits were submitted deprived us of the necessity to cross-examine those individuals, and those affidavits weren't good enough, even if the court were to consider, because they leave out necessary information to cure a defect. Had these people come in, I absolutely agree with you, Judge. If they came in and said, page 6, line 7, that's me, my intent is to sign, I wouldn't be before you. They didn't even come close. The evidence before this court in the record is unrebutted. They're handprints. We handed each of the voter registration cards. It's all properly in evidence. They don't match. And to even take it a step back further, the Erie County Board shouldn't have validated this petition. It overstepped its ministerial duties in doing so. There's absolutely no rhyme or reason how the commissioners or commissioner in some circumstances determined that this was acceptable. It becomes a fact-finding issue. And with each one of those, it's very clear in the record, it doesn't match the voter card. So how did a commissioner become a fact finder? That is separate for court. The respondents failed at court, and this petition must be invalidated. On the third point, if you have any questions, I don't think it should be considered. The military ballots have not even been sent out yet. The case is cited before the court, and I apologize. I mean, respondent's third point, that this is too late. It's not too late at all. All of the cases cited are far closer to the time of elections. In one case, it was a day before the election. In one case, it's 10 days before. Our military ballots haven't even gone out in Erie County yet. It absolutely can be corrected.
Thank you.
Thank you.
Just for the recess.